Good afternoon, good morning, and welcome to The Appeal Live, a co-production of Navis and The Appeal. I'm Emily Galvan-Almanza. Clearly we are all still in recovery from the election cycle of 2020, but brace yourselves, we are actually in the middle of another incredibly important contest right now that is going to have ripple effects for years in one of America's most populous cities. Manhattan's District Attorney Cy Vance is not running for re-election, which leaves 8 candidates vying to take his place. Under Vance's leadership, the Manhattan DA's office had a reputation for being regressive, prosecuting essentially every case brought by the NYPD, and that's according to analysis by the Vera Institute of Justice. Black New Yorkers are 20% more likely to be detained pretrial when prosecuted by the Manhattan DA's office. But depending on how this election turns out, all of that could change this year. The candidates vying for the seat seem to have more or less sensed that there is a sea change in the voter base. There is a public demand for something different. And all 8 have presented themselves as smart on crime or some version of progressive. But there are key differences in the policy promises that they are making. And those key differences make it clear that they will be very different DAs if elected. So it's very important for voters to know as they head to the polls this year exactly what those differences are, which is why The Appeal Live is doing a whole series of interviews with candidates for this seat. And today we are very pleased to be speaking with Eliza Orlins, the only public defender in this race and a frequent opponent of Cy Vance's office in her work at the Legal Aid Society of Manhattan. Good morning, and thank you so much for joining us.
Good morning. I'm so happy to be here with you.
All right, let's start with the totally minor, totally not important question of what will be the difference, if you're elected, between Cy Vance and you?
Oh my gosh. I mean, where do I even begin? There are so many differences. And as a public defender, I've spent my entire career going up against the Manhattan DA's office. And I've seen the cruel, unjust way that they've perpetrated this punitive and racist criminal legal system, how they've over-prosecuted the people I've spent my career representing, Black and brown people, lower income folks, people with disabilities, people who are LGBTQIA, sex workers, those who don't have power, wealth, and connections, and meanwhile not held accountable those who are powerful and privileged and well-connected. And I've also seen the way in which they've used jail as the default. The metrics of success are how many convictions you can get or how long of a sentence you can get someone sentenced to. And so I'll be like the polar opposite of that. I think we need to stop prosecuting low-level offenses. I have a whole decline to prosecute policy out, which basically states and promises that I will decline to prosecute the overwhelming majority of misdemeanors, many low-level felonies as well, and focus on people who are committing serious crimes, and offer alternatives to incarceration as the first rather than the last resort. And there are just so many things that need to change in that office. The culture of mismanagement and prosecutorial misconduct, which I saw with stunning regularity as a public defender. And really, we just need to change the values. We need to rethink what a DA's office can look like. And with a public defender in charge, I think we'll actually be able to do that.
I'm fascinated by this vision because you've run on this kind of proposal of defunding yourself. You talk a lot about shrinking the DA's office. And I just heard you talk about, of course, focusing on serious crimes, on crimes that people really, really care about and are profoundly harmed by. But you've also drawn this really nuanced line in prior interviews about the role of the DA in offering social services. Now, I myself, as a former public defender, I know that often the DA's office engages with social services through mandated forced treatment, often inpatient treatment. And those of us who have experience with substance use, who've worked with people who have experienced substance use issues, kind of know that treatment isn't treatment if it's forcible. But you've been discussing strategies for how you would essentially reallocate funding away from prosecutors and toward community programs. Can you walk me through what would that look like? How would that work? How would the average New Yorker experience that?
Absolutely. And I think that's such an important thing to focus on, because declining to prosecute cases shouldn't mean relying on these diversion or specialty or problem solving courts, because then you're just, it's still part of the court industrial complex. And these are another example of really net widening governmental intrusion into people's lives. And so to the extent someone is in need of services, they should be able to receive them, but they should be able to receive them independent of the punitive structures of criminal court. And so I think that, yes, the DA's funding right now is such that it is really incumbent on the DA's office to provide services if people need them, and then hang these convictions over their heads and treat people as though they are definitely in need of services if they had, an arrest for a personal possession of drug use case. And so the important thing that we focus on is that some societal problems, a lot of them, in fact, are better handled in public health sectors rather than in the criminal legal system. And so, yes, diverting funding into community-based programs and community-based organizations, and not having a district attorney who's like, I just want to be a good prosecutor. Oh, shucks, I'm just going to be out there being the person making sure that people get the services they need. No, it shouldn't be within law enforcement's job at all. And as much as I've spent my career as a public defender, I still recognize that I'm running to be a prosecutor, and that means that I should be somehow removed from these processes, because law enforcement is inherently harmful to Black, brown, and low-income communities.
It's so interesting to hear a candidate for elected office talk about the limitations of their own comparative advantage at doing a particular thing. So I want to move to something that we know you do have a comparative advantage in doing, which is impacting essentially the number of people who are held in cages in New York City and in New York State more generally. Now, if elected, you're taking the helm of an office that has been putting Black and brown New Yorkers into state prison for decades. We have very full prisons. When it comes to stepping back from this reliance on cages, you've discussed a few strategies that look both forward and backwards. And I'm hoping you can walk us through what those strategies are and how they would reduce the number of people who are already in prison in New York.
Well, that's a great question, because what we talk about often is reducing the number of people who we are sending to jail right now. And that, I think, is almost a more simple answer, because, I've pledged to end money bail. I've seen the racist nature of money bail and the way in which it disproportionately impacts people who don't have the wealth to buy their freedom. But also, there are so many people who have been put in prison due to the actions of the Manhattan District Attorney's Office. And so I have to go in there and really think through how I'm going to undo that damage that has already been done. And so there are so many ways of doing that. First of all, categorically, I've seen with every client I've ever had who's been up for parole, the Manhattan District Attorney's Office sends a letter, and it is a form letter that says the Manhattan District Attorney's Office opposes the early release of inmate blank, fill in the blank here. And so instead, if I join in every application, I've only ever once had the DA's office not take a position and once have them join in my application to get someone released early. And both times we were successful. So when the DA's office joins in that application, you can make a huge difference. But furthermore, I've proposed a very ambitious, groundbreaking revolutionary conviction review unit that will prevent these wrongful convictions from happening in the first place, and will be independent so it can step in at any point in the process, but will also do a huge review of every case that was handled by a prosecutor who has been alleged to have committed misconduct, or police officers that have committed misconduct. People really tout what DA Gonzalez is doing, especially my opponent, Tali Weinstein, touts what they're doing in Brooklyn. But there's still a detective out there who has led to the conviction of human beings who've been decades in cages, whose cases they will not review. If you think about Nelson Cruz's case, there are so many other examples. And so it's not like they're being so proactive to really exonerate all these people to get people out of prisons. And that is what I will do.
So I'm interested to hear about a couple of things. You mentioned, let's start with clemency. Will you have a strategy to support petitions or to petition the governor yourself for grants of clemency outside of the parole process or the conviction review process?
Absolutely. Definitely. I mean, if I think about some of the clients whose applications for clemency I've read, I mean, if those things were things that the public saw, there's no way anyone would be able to oppose that. I mean, if you think about how devastating it is that here in New York State, people can say, oh, we live in a blue state. We live in a place that no longer has the death penalty. And yet we are sentencing people to death by incarceration. If you are against the death penalty, you should be against death by incarceration as well. And I fervently am. And so absolutely joining in applications for clemency, actively seeking out those cases myself as well, to make sure that we are trying to get as many people out of our prisons as possible.
So, New York has not, you mentioned cash bail, and I know that no one in New York, I don't think, has recovered from the death of Kalief Browder, who died by suicide after being detained for years on Rikers Island, never convicted of a crime. After New York made strides on bail reform, state leadership, of course, rolled it back, which leaves this weird situation where DAs have massive power to influence pretrial detention. And you are one of the candidates who is committed to ending cash bail. But you've also branched into the dangerousness of algorithms, where we try to, use, I guess, like an automatic process to Minority Report style determine who's dangerous and who's not. You've criticized the use of race-influenced data going into those algorithms, which then makes racially biased outcomes come out of those algorithms. So keeping in mind that you as the head of the office are going to have to get the line DAs who are actually in the courtroom to do the right thing, can you explain how you are going to reduce the number of people who are held pre-trial in New York City?
Definitely. Pretrial detention should only be used in the most exceptional circumstances. And so it will require either my explicit permission or the permission of one of my executive members of leadership to hold someone pretrial without bail, because that's what we're talking about. When I say end money bail, that means the only alternative is remand. And that is so unbelievably restrictive that it should only be used in absolutely the rarest of cases. There are so many alternatives for pretrial services for if you think about the least restrictive means possible. I mean, electronic monitoring is still quite restrictive in a lot of ways. Supervised release. There are so many ways that we can ensure someone's return to court, which is the purpose of bail, without detaining them in cages, without putting them at Rikers Island. When someone is detained pretrial, we know that the outcomes in their cases are worse, that they take worse pleas, they have longer sentences, they get saddled with criminal records, they plead guilty if they're innocent, because getting detained pretrial is so coercive. And so if we have a presumption of innocence in this country, we should also have a presumption of release. Pretrial fairness is something that's absolutely critical to me. I've put up a long policy on my website about it, elizaorlins.com. People can go check it out. But I think that that's something that we have to be focused on, because the DA has massive, massive power.
So when you say something like, if we have a presumption of innocence, we should also have a presumption of release, the thing that pops into my head is the people who are pushing back on that. Because obviously one of the biggest obstacles in the state to larger policy reforms or legislative reforms of the kind that you are describing. Obviously you can do that policy internally, presumption of release, got it. But the DA's Association has been a very, very powerful enemy of reform in New York State. Things that are intended to make the system fairer and more humane, like bail and discovery reform, are like anathema to the DA's Association. So if you were elected, would you pull out of the DA's Association? And how would you have influence in Albany if you were no longer part of that association?
Well, I would absolutely withdraw from DASNY on day one. They have been an absolutely regressive obstacle to reform at every turn. And I've fought against them my whole career as a public defender. So absolutely, I would never participate in DASNY. But I think the way I would have influence in Albany is the same way that I have had influence in Albany thus far. I've always been an activist. I've spoken up for these things. And now, instead of just being a public defender, I will be the Manhattan District Attorney. And so that bully pulpit from which to advocate and really push for real legislative changes will be quite powerful. And I think that that's how you make these changes, by showing that they work. Because I think that these people who have fear-mongered around money bail and around these types of reforms fail to actually understand what is keeping us safe. We're sold this false choice between public safety and incarceration. And in fact, locking people up, especially on low-level amounts of bail, is not keeping us safe, and it never will. What we're doing is cycling people back through. We're making it more likely that they're going to get rearrested or reoffend. And so, in fact, we have to end money bail, and it will keep us safer.
I appreciate you linking back to public safety, because so often that's the core of what voters are actually concerned about when we talk about the criminal legal system, we talk about prosecution, and also when we talk about policing. So over the summer, we saw some truly shocking things from the NYPD, perhaps not shocking to people who have been working with the NYPD, but I think the larger public was really surprised and horrified to see police driving a vehicle into a crowd of protesters. But there are other longstanding criticisms of policing in New York that predate the summer. Vice units harassing trans New Yorkers, narcotics units that spend their time arresting methadone patients for sharing medicine, school resource officers who beat up kids, a gang database that's notorious for criminalizing race and poverty and relationships rather than actual crime. So what would you do as DA? I know you're not going to be the head of the NYPD, but what can you do as DA to protect New Yorkers from dangerous and bad policing?
Well, all of the things you just mentioned, we absolutely have to disband Vice. We absolutely have to stop using gang databases and just completely abolish them. They're overwhelmingly racist and consist of 99% people of color. But we also have to make sure that reforms and accountability are prioritized by the district attorney. The current Manhattan DA's office has really been complicit in the continuing misconduct perpetrated by the NYPD. And again, we're not just talking about the physical violence that we've seen in the streets, the brutality and harassment and assaults that they've perpetrated on New Yorkers, but I'm also talking about the things that I saw with stunning regularity as a public defender, such as, false arrests, falsifying of documents, and perjury in the courthouse. Police officers walk into 100 Center Street and they walk into a grand jury or a hearing in front of a judge or a trial in front of a jury. And they say, "You swear to tell the truth, the whole truth, nothing but the truth." "I do." And they get on the stand and they lie under oath. And those lies, even if a defense attorney is able to bring them to light, never have any repercussions. Whoops, okay, I guess the case gets dismissed. And then I bring it to the attention of the DA's office and is anything going to be done? Nothing is done. They are complicit in this misconduct, and they shield and protect bad police officers from accountability rather than holding them accountable. And so I think, it's absolutely critical that the next Manhattan DA be someone who's going to prioritize accountability. And that's exactly what I want to do, that I will prosecute bad police officers. I will not allow this to stand. I will be unbelievably transparent with the public, because they have the right to know, and make sure that all of this is publicized, in a way in which people can actually access it and understand who they have policing their communities.
So does that mean extending to the use of a do not call list? For officers is there anybody who wouldn't get prosecuted? Is there anybody who would just say, "I'm just not working with that particular police officer"?
100%. Definitely. Absolutely. A no-call list is critical. Tali Weinstein talks about creating a no-call list in Brooklyn, but when you actually dive into it and look how many officers were on that no-call list, it was 8. 8 police officers. We know, and I can name more than 8 from my time as a public defender, in Manhattan that deserve to be on that list. It's dozens, if not hundreds. And so this has to be something that is taken incredibly seriously, and that misconduct lands you on that list, and then you don't get to be a witness, especially in cases where the sole witnesses are law enforcement, to put someone in jail or prison.
That's really striking. I guess it really points out that the devil's in the details, in terms of what people mean when they talk about these policies and the ideas like a do not call list. Ms. Orlins, thank you so much for joining us. Thank you for talking with us about this today. I wish you the best of luck going forward, and I look forward to talking with you again soon.
Thanks, Emily, and thanks for always covering these important issues. I'm so grateful for you.
No problem. It's my pleasure. There you have it, another candidate for Manhattan DA, Eliza Orlins. I hope you all will go back and, like, once we finish all these interviews, just binge them all and make a decision based on what the candidates are actually telling you and the details they are giving you about the differences in their policy positions. This is The Appeal Live. You can follow us on Facebook or Twitter. I'm Emily Galvin Almanza. Look forward to seeing you again soon.